I take that as an agreement that it would be possible for a state to come up with procedures that would violate the Eighth Amendment, right? I mean, you wouldn't want to rule that possibility out.
Oh, of course. I mean, that was exactly what happened in Hall, and in Moore, for that matter, and in Brumfield. And in every single one of those cases, the court remanded to the state courts, which then heard all of the relevant evidence, not just IQ test scores, all of the relevant evidence, and concluded that the defendant had, in fact, satisfied his burden to show all three prongs.
Mr. Waxman, if a state law goes above what we might say the Eighth Amendment floor is, and a federal habeas court deviates from what state law requires, does it violate the Eighth Amendment?
No. I mean, the example would be, let's say a state said, look, we've read all the other cases, but in our state, we're not going to execute anybody who has a true IQ below 80. And we're going to hear all the evidence, but a true IQ below 80, you win under state law. A federal court couldn't say.
Couldn't grant habeas in that circumstance.
Right. Yeah. Right, unless there was a compelling argument that the true IQ was below 70.
Right. Right.
Yeah.
But it might be a violation of state law, but it isn't a violation of the federal Constitution.
That's right. But what we have here is a situation in which every state, with the limited, very limited exception of Oklahoma, says IQ test scores are not the same as, are not equivalent to substantially sub-average intellectual functioning, because that is a condition, not a test score. They are highly probative, considering the standard error of measurement of what actual IQ is.
So we don't have to really consider Alabama law, because what you're articulating is the Eighth Amendment standard as you see it, based on what you're pointing to in a consensus of the states. But just to kind of clarify the position on this thing we've been going back and forth with about what is the role of state law, really Alabama law here does not matter to your argument.
Alabama law matters a great deal to my argument because, as this court has taught, we leave it to the states to apply appropriate means for enforcing the Eighth Amendment guarantee. And that is what the Alabama appellate courts have said repeatedly that they are doing in considering both evidence of IQ test scores, if there are any, and where those scores are determined upon expert testimony to be inconclusive, other evidence of intellectual functioning, including, in this case, 4 other psychometric tests that test intellectual functioning, and a history where in the 7th grade he was medically diagnosed as mentally retarded. And considering all those factors, the court found, both the district court and the Court of Appeals made clear on remand, that with respect to evidence of intellectual functioning, including but not limited to test scores, he satisfied prong 1. The Court of Appeals then went on to say, in its opinion on remand for this court, that the additional evidence, I'm quoting from page 8A of the Joint Appendix, which is quoting from Hall, the additional evidence of Smith's adaptive deficiencies plausibly supports the district court's reading that although Smith scored above 70 in IQ tests, his actual functioning is comparable to that of individuals with a lower score.
Thank you, Mr.